We are the Armed Attorneys. Today we're going to talk about who is qualified for a Texas license to carry under Texas Government Code 411.172. So our government code, that's where our subchapter H, or handgun licensing provision, lives, and it has all of the different provisions that apply to handgun licensing, including suspension, revocation, eligibility, what the application process looks like. And so a lot of people want to, ask, like, am I eligible for an LTC? Why should I get an LTC? Now that we have Texas constitutional carry, what do you say to those people, Emily?
Yeah, well, and I think first we should note this is all still very much in effect. We did not lose our LTCs in Texas. You can still get a license to carry, renew a license to carry. The Texas Government Code, subchapter H, chapter 411 is still there in full effect, even though we now have constitutional carry in Texas. And yes, there are lots of hoops to jump through. There are lots of restrictions about who can or cannot get a Texas license to carry. However, when you're asking yourself, should I get one? I think the answer is yes. I'll maintain mine. I know you'll maintain yours.
Yeah, I tell all my clients, if you have a license to carry, renew it, because there's just too many benefits.
Yeah, and it's too much for us to list out all of the things that exist in the law, just little ticky-tacky benefits here and there. Something that's not listed in statute, but I tell people all the time is, if you ever have to use that weapon in self-defense, and I'm talking to your jury at trial, I want to tell them that you went to a class, you learned the law, you have a license to carry, you've done everything that you can do to be the most responsible gun owner you can be. You're not going to find that in the Texas Penal Code or in the Government Code, but if you are thinking about an LTC in light of constitutional carry, do it.
Yes. And so getting to the meat of this discussion, let's go through the eligibility criteria. Am I eligible for a Texas license to carry? I have them listed off right here, and we're going to discuss them. The first one is be a resident of the state of Texas for the 6 months prior to your application if you're applying for a resident license. Now, Texas, we issue non-resident licenses. You could be a resident of the state of Oklahoma and apply for a non-resident Texas license to carry. So that qualification doesn't apply. But if you're applying for a resident Texas license to carry, got to be in the state for 6 months. The next one is be at least 21 years of age or older. So that's our federal law on purchasing handguns from FFLs. So that one's easy.
And I think we should note there are some exceptions to that.
Exactly.
Active duty or honorably retired members of the military, people who are, essentially domestic violence victims. There are some 18 and up exceptions, but your general rule is 21 years of age.
That's a very good point. Yes, this past legislative session, we had all of these new people who could get a Texas license to carry potentially, especially the domestic violence folks. The next one is you can't be convicted of a felony. That makes sense. So our felons, that means you've been convicted of a crime where the possible, period of punishment is greater than 1 year. That doesn't mean how much time you actually served. You could have even served a probation, but if it was possible that you could have been punished by more than a year in jail, you're going to be considered a felon.
Well, and I think that we need to talk about what conviction means under the Texas license to carry law as well, because it doesn't mean you actually were convicted of a crime. For these purposes, being placed on deferred adjudication, that's your non-conviction probation. So you've been placed on that if you served something that looked like probation, but that when you successfully completed it, your case got dismissed. For the purposes of getting a license to carry in Texas, and for this purpose only, so nowhere else in your life does this matter, but for the purposes of license to carry, that is counted as a conviction. And so if it was a felony, you've got to wait 10 years after that conviction. Misdemeanor.
Well, the deferred.
Right. Again, it's not a real conviction, but for these purposes, it is. Misdemeanors, you've got to wait 5 years.
Yes. The next one is you can't currently be charged with a class A or B misdemeanor or disorderly conduct or some kind of equivalent. So that one's pretty straightforward. You can't be a fugitive from justice for a class A, B misdemeanor or a felony. So fugitive from justice, that means that there's a warrant out for your arrest for, one of those degree offenses. So that means you're on the run. The next one is you can't be a chemically dependent person. Now, what is the DPS looking at when they're seeing whether or not somebody's chemically dependent? Have you seen people denied who have lots of DWI convictions?
Oh, sure. So they are going to pull your past. And there are things in the law that say basically this is on its face evidence that you're a chemically dependent person. And having alcohol related convictions, whether it be DWI,
public intoxication, intoxication manslaughter, even, well, that's a different discussion.
But yeah, these are issues where the DPS is going to pull your background and say, man, he's got 2 convictions in the last 10 years that were alcohol related. That is our evidence that he's chemically dependent.
And so the some more qualifications going on. Can't be in the previous 5 years convicted of a class A or B misdemeanor or disorderly conduct crime. So earlier we talked about convicted felonies or those deferreds. Now we're talking about misdemeanors. In the previous 5 years, you cannot have been convicted of a misdemeanor. The next one, you have to be fully qualified to purchase firearms and ammunition under federal law. I see a lot of clients get disqualified for not meeting this exception. So the way that works is when the person applies for their LTC, they would get denied for, one of those qualifications that would make you qualified to, if you filled out a 4473, for example, you went to a gun store. If you'd have to answer yes to any of those questions that would disqualify you, we see a lot of people get knocked out there as well. The other ones, can't be delinquent on child support from the Attorney General of the state of Texas. You can't be delinquent on your taxes to the comptroller or some other taxing authority. Can't be under a protective order. That makes sense. And then that 10 years prior can't have been on a deferred probation, what Emily was talking about earlier. The final one, and this is where I see most people get knocked out of their application process, is material misrepresentations. Can you talk about that, Emily?
Yeah, so this is where, we have people call in all the time and say, should I disclose this arrest on my application? And the answer is always yes, because let's say you were arrested 15 years ago for a DWI, you were convicted, that's fine. You are fully eligible for your license to carry. But if you don't tell the DPS about it, they're going to find it. And then there's a chance you get denied because you made a material misrepresentation, which is that you were not arrested for this offense. They can get you if you just don't tell them the truth. And so it is important to know, and there's a distinction here, I think, between your criminal background, and there are also some issues when it comes to your mental health. DPS will ask questions. There are some disqualifying mental health disorders that'll keep you from getting your license to carry. They are few and far between. And they're, we're not talking about PTSD, anxiety, depression. We're talking about bipolar disorder, schizophrenia, intermittent explosive disorder, antisocial personality disorder, amongst maybe 1 or 2 others here. But, there's a difference here between what the DPS can find and pop you on for this material misrepresentation. Your arrest record in full view of the DPS, unless your offense has been expunged. However, your medical history, that's a different story. It's really hard for the DPS to find that and give you a material misrepresentation pop on that.
Right. And this is, this is a summary. Sorry, I hit my mic. This is a summary of the qualifications. You need to go to 411, 172 and read them just so that you understand. But we're talking about these concepts generally. And what Emily was talking about there with the mental health background is you also have to be capable of exercising sound judgment with regard to the handling and storage of firearms and ammunition. And that's where the DPS kind of shoehorns the mental health issues under. The other thing with the material misrepresentations that I wanted to add is a lot of people would have an arrest, and the way that it's worded on your LTC application is, have you ever been arrested or charged with any crime, even if it was a long time ago, even if it was another state, even if you're a juvenile. They make it so broad that like Emily said, it's just disclose. Because what we see is people who would be eligible, let's say they had a public intoxication arrest from 10 years ago. Well, that person would still be eligible for it. If they had nothing else going on, they would still be eligible for a Texas license to carry a handgun. But if they don't disclose it on their application, they're gonna get denied for that material misrepresentation portion. So just disclose. That's probably the best advice that we would have on that. The other thing that I would say is, if you have questions about this, and whether you're qualified, speak to the attorney that represented you on those criminal matters to figure out exactly what information you need to include, because the DPS really wants to know the arrest date, the agency that was involved, the state that it was located in, the charge itself, and what the outcome was. Those are the real 4 or 5 pieces of information that they're interested in. If you don't know that, go to your county clerk for misdemeanors, your district clerk for felonies, speak to the attorney that represented you. They'll have all that information for you, so you know exactly what to put on your application.
And it's a good idea while you're doing that, go ahead and order a copy of what's called your disposition paperwork. That's going to tell you the final outcome of the criminal matter, whether it was dismissed, whether you were placed on probation, deferred, convicted. The DPS is probably going to ask you to follow up with that paperwork anyway. So while you're sussing out this information, go ahead, get that disposition paperwork from the clerk the offense occurred in from that county, and that'll be really helpful right up front.
Well, I hope this overview of Texas Government Code 411-172 LTC eligibility helped you. Thanks for watching. Hit that like button. Consider subscribing if you enjoyed this content, and help us fight the anti-gun algorithm by sharing this video.
And as always, we appreciate y'all's questions, your discussion in the comment section below. And until next time, we're the Armed Attorneys.